All right, let's talk about estate planning and just the basics around it and why we do estate planning as part of overall financial planning. And as per tradition, for some disclosures, this is a very basic overview of estate planning. We're not getting into complex issues. I am not an attorney. I am a financial planner. This is not legal advice. It's also not financial advice. It's education. And if you are an attorney, my niche for my financial planning practice is BigLaw attorneys. So if you have found this and you're watching this because you're an attorney, you probably know law better than I do. And so I'm not trying to talk about law. I'm trying to talk about estate planning in the context of financial planning. You need to consult a qualified attorney in your state when it comes to getting estate planning done and getting all the documents in place. All right, so with that, let's move on. All right, so when it comes to estate planning, what are we talking about when we use the term estate? A lot of people think, I don't have an estate. I'm not Scrooge McDuck diving into a pile of gold. We're not talking about like the vineyard in California and the mansion in the Hamptons. You don't need to have some super rich lifestyle to need estate planning. We're talking about caring for your loved ones and caring for yourself. So in the context of your loved ones, this is if and when you die, probate issues or not. If you set up a trust and manage to avoid having your survivors in your estate go through probate, that's one avenue you can take. But we're talking about the documents that make all that happen. So whether you do any estate planning or not, you will go through probate. The only option is if you do estate planning and get everything put into trust, that will avoid probate. But even if you don't set up an estate plan or get your estate documents in place, your loved ones are going to have to go through probate. And if you haven't put together your estate planning documents, it is going to be a hassle and it's going to be expensive, a lot more expensive than getting the documents done in the first place. So when we talk about caring for your loved ones, we're talking about probate or the avoidance of probate and the documents that make all that happen. When we talk about caring for yourself, we're talking about medical documents. What happens if you're incapacitated and can't speak for yourself? So let's focus on that next. All right, so medical, this is really straightforward. If you are incapacitated in some way, sitting in a hospital bed, what are your wishes for your ongoing care? Who can make decisions about your care and on your behalf, and who can control your finances? All of these questions are going to be answered one way or another. It's just a matter of whether you're going to have your input voiced in this via some official document that tells the doctors and your family what it is you want, or whether you make your family guess about it. And, you may think, well, my family knows what I want. Well, they may have different interpretations about what you want. And it's going to be an emotional time for your loved ones and everybody involved. So do not force your family to make choices without your input. It is cruel. And do not make yourself helpless and broke. Because what happens if you're incapacitated for an extended period of time and nobody knows what they're supposed to do or what you want to do? Nothing's going to get done, and it's going to cost a lot of money. And it's more important than all of that is it's going to be extremely difficult for your loved ones and your family. Do not put people in this position. All right, so on the other side of this discussion is the probate discussion. And probate is the disposition of your accounts and your money, like in your assets or your stuff. So you got to think about how much in legal fees will your estate or family rack up trying to figure it out. So if you die with some amount of money in your bank accounts, that probably can be used to help dispose of the estate, but there may not be anybody with access to it for quite a long time if you don't have clear written instructions about how those assets are supposed to pass, and that can be a real problem for your loved ones. If you go the route where you get a will, the cost is largely incurred when you die and probate happens. So the will gets adjudicated through probate. And there is a cost to setting up the will and getting it put in place, but it's typically de minimis relative to the cost of dying without a will. I believe very strongly that is the case. You can also go a trust, the route of having a trust. And in that case, the cost is largely incurred with the maintenance of the trust, and obviously with the setup of the trust as well when the documents are drafted. But a trust, generally speaking, will help the assets held within the trust avoid going through the probate process. So in both cases, you're going to incur fees to set these documents up. In both cases, I believe the fees that you incur through this will be lower than what would happen if you died without any documents in place and everything had to go through the probate system without any instruction or direction. If you do the will, you set it up once, you review it every few years or whenever you have major life changes, and then when you die, there will be some legal costs associated with going through the probate process. But assuming your will is put together correctly, it should be pretty clear to the parties as to what is to happen, and it shouldn't be tremendously expensive to go through the probate process. With a trust, you set it up, and there is ongoing maintenance of the trust. You need to make sure that once the trust is set up, that you actually put assets inside of the trust. There may be legal fees on an ongoing basis with maintaining the trust, but once you die, the trust document should take over, and for the assets held within the trust, it should help avoid the costs associated with putting them through probate. All right, so trusts, a lot of this can be confusing, but this is especially where things can get confusing. So there are many different kinds of trusts. There are different, what I would call groups of trusts, revocable, irrevocable, different things like that. And then there are subcategories underneath each one of those. So there are different kinds. Some trusts are created through the will, and others are separate entities. So what I want to do is focus on those that are testamentary trusts, the types of trusts that are created in the process of the will being going through probate, as opposed to these separate legal entities down here that are sort of the more complex trusts that may be used to avoid the probate process altogether. Okay, so in order to explain the necessity of having a trust, what I'm going to call a testamentary trust that can be created through a will, I'm going to use a hypothetical couple that has children. There's adult 1, here's adult 2, here's child 1, and here is child 2. And both of these children are minors in the state in which you live. Now, traditionally, if one of the parents dies, often the intent is for the surviving adult to get all of the stuff. It's pretty straightforward. If adult 1 dies, then adult 2, generally speaking, most people just want their assets to pass to adult 2. If adult 2 dies, they want their stuff to pass to adult 1. Now, this can be different. If you're in your second marriage, you may have other trusts or other things set up such that if you die, that there are assets set aside for your biological children and so on and so forth. But for our purposes today, let's just assume that adult 1 and adult 2 want their stuff to go to their survivor, adult survivor, in the event that they die. So the question is, what happens if both are to die while the children are still minors? So if both of these adults were to die, often the intent is for the children to be taken care of by the parents' stuff, your money, your house, your assets. But who takes care of the kids? That is the guardian. And who takes care of the money? That is the conservator. These minor children, your 3-year-old and 5-year-old, can't handle the money. Even your 18-year-old may not be able to handle the money. And they presumably can't take care of themselves. And so you're going to have a guardian, and you're going to have a conservator. Now, those people, the guardian and the conservator, they're going to be named. The question is, are they named by a court who you don't know and doesn't know you and doesn't really care, or are they going to be named by the will that you have set up? That is the big question. Okay, so enter the will. This names the guardians. It contains language to create a trust, like a testamentary trust, if that's necessary. It names the trustees, the people that take care of it. It defines the terms of the trust, like my child can't get all this money until they're 25 years old, or maybe some when they're 25, some when they're 35, some when they're 50, however you want to do it. It defines the terms of the trust if and when that trust comes into existence. And generally, it can be written to contemplate future children. So it may say, I currently have this child, and this also covers any future biological children that I may have or whatever. The attorney will draft it the appropriate way. But just understand that the will is going to name the guardians for the minor children. It's going to contain the language to create the trust if you both die, or if you are single and you pass away. But should a trust become necessary to take care of the children and hold the assets, it will contain the language to make that happen. It will name the trustee. It will define the terms, and it generally can be written to contemplate future children. All right, so I have convinced you to go get your estate documents in place, but you're not done yet. You have to update your financial and insurance accounts to align with the will or the trust. So let's say that you go and get a will done, and it creates this testamentary trust to care for your children in the event of, the parents or the adults dying. If you still have somebody else named as the beneficiary on your financial accounts or your insurance accounts, these are going to take over and they're going to supersede whatever the will says. The assets, whatever it is going to pass by way of contract through the beneficiary designations here, and they're going to override whatever is written in the will. So it's not enough to get the will done and think, well, my will says it, and therefore that's what's going to happen. You really need to go update the beneficiaries on your financial accounts, on your insurance accounts, to align with what is written in the will or in the trust. As I said, beneficiary designations supersede the will. And be aware, some institutions, some banks, some insurance companies will require their own forms in addition to the will. So nightmare scenario is you've done everything that you were supposed to do. You've created the documents, you've changed the beneficiary designations, and then, God forbid something happens, you die, and the survivors go to the company and say, hey, here's the documents, we need, you to process all this stuff. And they say, well, they didn't fill out our form, and therefore we're going to put you through the ringer to make all this happen. It can be a huge hassle. So it is important for you to talk to those institutions and determine if they have their own form. They may require you to submit a copy of the will or the trust documents. And it's a hassle. It's annoying. I can't stand it if you can't tell from my tone of voice. But nonetheless, it is the reality of the situation. And so obviously, if you're working with a financial planner, have them help you with this. But if you're not, this is something that you need to get done. Make sure it happens on your own. All right, so let's catch our breath and get the general overview of estate planning as I've gone through it. Basically, I perceive it as being two separate groups of documents. There are medical documents and there are probate documents. Medical documents are so straightforward, I'm not even going to waste our time with them here. Go get them. You need them. There is not a situation in which, in my opinion, you don't need this. Just get that done. For probate documents, there's a little bit of nuance there. There's a couple of routes you can go. You can have a will. You could go the trust route. You really could go both routes, I think, but check with your estate attorney. If you go the route of the will, it's going to take money to set it up, and it's going to cost money to probate, to go through probate. It's going to cost less than if you don't do this at all. It's a relatively simple process. There are generally taxes involved, and whatever happens in the will is public information. So for people that are concerned about privacy, this may not be the route that you want to go because these are done in the court system and that information is public. This may include a testamentary trust. If you have minor children or you have children that need lifelong care, special needs, that sort of thing, this may include a testamentary trust. On the trust side, not testamentary trust, but the actual separate legal entity that is a trust and has its own tax number and everything, this is going to cost money to set up and maintain. It's more complex. You can use trusts for tax strategies in the context of estate planning, and generally these are more private situations for people that want to maintain privacy. A trust can be an attractive route to go. This also, I put this in here, a trust may involve life insurance. This is one of the rare cases where a whole life insurance policy or a permanent insurance policy, there's many names for it, Generally, those are vilified for good reason. Whole life is generally oversold and sold for inappropriate reasons to people. But one of the rare cases where whole life can make sense is in the context of a trust, an ILIT, irrevocable life insurance trust. This is something that your estate attorney should hopefully bring up to you if it's relevant, as opposed to an insurance salesman. But just be aware that if they bring up the need for whole life insurance within a trust, that can be part of a tax strategy, and it may be a valid, reliable strategy. All right, so who needs what? Medical, everybody. I think everybody should have medical documents in place to tell doctors, family, friends, what are your wishes, who can make decisions on your behalf, who can control your finances. That's just so straightforward. It drives me nuts when people don't get this done. Probate. It may be less urgent if you're single with no kids and you have enough life insurance through work to cover all of the costs that are going to be incurred when your estate goes through probate. So there is a little bit of wiggle room here. There are certain scenarios with financial planning clients where I say, hey, look, although this is something you should look at and get advice on from a qualified estate attorney, this isn't our number one priority at the moment. Medical is, and usually the estate attorneys do these documents as a package deal, so you might as well get it all done at once. But I will give a little bit of wiggle room for people, certain demographics, certain part of your life, where the probate isn't as urgent, but the medical always is. All right, now time, if you've made it this far into the video, God bless you, thank you. Here is some random bonus stuff. So often you may, on your beneficiary forms, have to elect whether you want your stuff to pass per stirpes or per capita, and you may not be sure what that means, so I'm just going to teach it to you here. So let's say there is 3 generations of family. We have parents, we have 2 children, and each of these children has 1 child themselves. So there are the parents, there are the children, and there are the grandchildren. If the 2 parents were to die, and they were to name their 2 children as beneficiaries of their assets, let's pretend, unfortunately, the first child has died. So there's only 1 remaining child of these 2 parents. The way per stirpes works is that the assets that would have gone to their second child pass to that person's grandchild. So they just go down to the next generation, and the child number 1 still gets their original 50% share, and then that person's nephew or niece gets the other 50% that should have gone to the sibling, but did not because they predeceased. In the case of per capita, if both parents are deceased and one of the children has predeceased, and originally we were going to send 50% of the assets split between the children, 50% each, now, because this person is not here to receive their share, this child gets 100% of the assets and nothing goes to grandchild number 2. This is the per capita way that things work. So I hope that's not too confusing, but that is the difference between those 2 elections. And the last random bonus is just illustrating the flow of things and what I will admit is kind of a zany, irreverent way to draw it out. But if you have a will and you pass away, it goes through the court system, it costs a little bit of money, and the will tells the courts and family who are going to take care of your children's finances and who is going to take care of their guardianship, and these are presumably loving people that are going to care for your children. If you don't have a will, it's going to go through the court system. It's going to cost a lot more money. The court is going to name the conservator and the guardian. They're likely going to be paid for their services, and you may or may not like who they would name, and that's why they're all colored red, and it's just a little bit, it's not a little bit, it's very dangerous in my opinion. If you have a trust and you pass away, it goes to the trust document instead of the court system, and presumably the trust document does all the same things, declaring who's going to take care of the children, how they're going to be taken care of, who controls the finances, and presumably it's loving people that are going to have the best interests of your children in mind. That is how things flow. Final message, just get this done. Nobody wants to prioritize it. Very few people believe that this should be a priority. You're not likely to die soon. This probably isn't going to be a big issue anywhere in the near future. It's going to cost money to get it done. It's going to take time to get it done. I don't care. It is so important. It is so important in the context of your financial planning and taking care of your family, taking care of yourself. Usually you get this done and you don't have to address it again for 5, 10 plus years, unless you have a major life change like a marriage or a divorce or whatever. But just get it done. Nobody wants to do it. Nobody likes to do it. It has to get done. It is incredibly important. Just get it done. All right. Thanks. Bye.